The big news in bankruptcy circles this week is the long-awaited decision from the U.S. Court of Appeals for the Second Circuit in Manhattan, reversing the district court and reinstating Bankruptcy Judge Robert Drain's confirmation of the Chapter 11 plan for opioid maker Purdue Pharma. This is a really big deal because the Second Circuit stepped right smack dab into the middle of a major circuit split and held unequivocally, at least according to the two judges who agreed, that the bankruptcy court has power and jurisdiction to issue non-debtor third-party releases of direct claims that creditors hold. Now, I don't have time in this short video to explain the significance of this opinion or what the basis for the holding was. But if you're interested, look at my column appearing on the ABI website on May 31. And that column also has a link where you can read the entire 94 pages of opinions in full text. But what I want to do is to tell you what the time schedule is, because I don't think this case is over. Assuming that the Solicitor General and the Justice Department agree, the U.S. trustee in New York can file, and probably will file, a motion for rehearing en banc. The reason I think there could be an en banc motion is that the concurring opinion was actually a dissent. And in that dissent, one of the judges on the Second Circuit was urging the U.S. Supreme Court to grant certiorari and resolve this circuit split about non-debtor releases. Well, if the U.S. trustee gets busy and files this en banc motion soon, it should be denied probably sometime during the summer if the Second Circuit doesn't spend a lot of time deciding whether to rehear en banc. Now, if the Second Circuit denies the en banc motion, then I think it's a sure thing that the U.S. trustee and the Solicitor General are going to file a petition in the Supreme Court for certiorari, asking the High Court to resolve that circuit split. Now, further, assuming that the U.S. trustee gets the motion filed by sometime around midsummer, the response should be in, and that means, in the best of cases, that the Supreme Court would tell us in early October whether the court is going to grant certiorari or not. And if the court grants certiorari and tackles this very difficult but important issue, argument will be held sometime around the end of the year, and that would tell us to have a decision handed down by the court, probably between April, May, and June of 2024. I am Bill Rochelle, the editor-at-large for American Bankruptcy Institute. I will return same time next week with something important about the world of bankruptcy, but frankly, I don't know that we can top the Purdue opinion that was handed down this week. Thank you and good day.